May I please, your lordship? With respect from the other side, lordship, I beg to mention item number 3. Lordship, in this matter, we are awaiting some instruction from the department, so it may be taken after.
Yeah, always awaiting instruction. The last 2 times also instruction.
The instruction has not come yet, lordship.
Then we'll call them. Who do we call? Let them come.
Lordship,
Commissioner Central Excise, we'll call him.
Last chance,
Let him
lordship.
come.
Lordship, last chance.
I will inform my lord that commissioner was changed, my lord. The new commissioner has come. That is
Okay,
why, my
that's
lord.
fine.
Mr.
K. Jain,
K. J. Learned
Behalf of
counsel appearing
specific
for the
appellant, lordship.
apparent. Submits that he needs some more time to appeal something. Mr. J. Wala appears for the respondent. Accordingly, release it after the case.
Lordship, much obliged.
May please, lordship. Lordship, I beg to mention an IA for listing, lordship. IA criminal. Lordship,
After the case,
lordship 24th or 25th.
what? Regarding what?
Lordship, this is a criminal appeal against Boxo, lordship, and he is in jail, lordship.
So,
So, lordship,
okay, you want to take a
for
chance.
orders, lordship.
You want to take a chance.
Yes, lordship. On 24th, lordship.
Okay.
Obliged, lordship.
Yes. Okay. So, earlier, the seats were to be distributed in terms of the notification dated 9/12/86, correct?
9/12.
12/86.
No, Your Lordship, every year the
Earlier, I said I've used.
point of time, at that point of time, Lordship.
Understand the words I use.
Okay.
I said earlier.
Yes,
I have
yes,
not
yes.
said now.
Yes,
So earlier it was 9/12/86.
yes,
That was changed.
yes.
Now the latest is that
28/7/25.
yeah, 2005. Correct.
Yes,
So this is the latest now.
yes.
So the only thing is the interpretation of that according to them is that they are not the writ petition is eligible for it.
Yes, yes, because he's not holding a civil post. And in that regard, Your Lordship, there is now a Supreme Court judgment of 5 judges. Your Lordship, it's 1967 SEC online, AC 385. Yes. Here, the 5 judges bench, they have decided that a person who is holding a post connected to the defense does not hold a civil post.
Yeah.
Yes, that's paragraph 13 and 16, Your Lordship. 13 and 16.
Yes, Mr. Akshay, is it?
Please, my lord. I seek permission to appear through VC, my lord. May I address the honorable court?
Yes, yes.
Please,
No
my
problem.
lord. As far as my lord, the document produced by the learned CGC on the last date,
Yes.
your lordships have in your lordships order recorded in paragraph 3. If my lord will kindly have the last order, my lord,
Yes.
dated 18th September.
Yes.
Mr. Gogoi submits that as per instructions received by him and in terms of the letter numbered so and so, dated so and so, issued by the Under Secretary to the Government of India, which is addressed to the learned CGC. Clause 4 of the Office Memorandum dated 28/7/2025, my lord, this is the guidelines covering the issue of Nagaland seats, is not applicable and does not include army personnel. Now, my lord, I beg to differ, my lord. In fact, the letter itself says that the Ministry of Defence seats are in addition to state of Nagaland seats, and there is no conflict. Nowhere
where
does the
does it
letter
say?
say. My lord will kindly have the document that the learned CGC had submitted on the last date.
Yes, we have got
Your
it.
lordships may, your lordships may kindly see paragraph 6, my lord.
Yes,
But they don't exclude me. They say, so far as the matter related to treating of army personnel as central government employee in clause 1.2.4 of the ministry's guidelines dated 27/7/2025, it is informed that these seats are allocated to the state to compensate for shortage of medical infrastructure and to provide opportunities for the student of the state to integrate into the mainstream. Additionally, a separate quota is reserved for army personnel under central pool seats. But in my humble opinion, this means that the Ministry of Defence seats are in addition to and not in derogation of the seats given to the state of Nagaland. This, in my humble view, cannot be interpreted to say that army personnel are not covered. In fact, if I may be allowed to submit this letter has in fact, propagated the confusion further instead of clarifying it.
Mr. Gogoi, you heard what he's saying.
Lordship, I have heard. So Lordship may kindly peruse paragraph 4 of my letter, Lordship.
Yes,
Paragraph 4 of the letter, Lordship. The beneficiary, may I read, Lordship?
yes,
The beneficiary state government, ministry and departments in compliance with the guidelines of the ministry issues guidelines to be followed during the selection and nominations for the suitable candidates for MBBS, BDS seat. Copies of the guidelines so and so is given, Lordship. Then my lord may kindly come to 5, Lordship.
yes.
Under the central pool quota scheme, 42 MBBS and 4 BDS seats has been allocated to the Nagaland. And then Lordship, 42 MBBS seat and 3 BDS seat has been allocated to the Ministry of Defence for being allotment to the ward of the defence personnel for academic year so and so, so and so. That paragraph itself reflected Lordship, 42 central pool quota especially allotted to the Lordship, state of Nagaland for their deficiencies part. And even Lordship, another 42 seats are allocated to the defense personnel. That paragraph itself indicates Lordship that part 2 seats are total different categories, Lordship. It is there. Even Lordship, that was done in respect of all of our India 30 medical colleges. Seat allocation seat is also here also.
May I, my lord, supplement my friend's submission on one point?
Yes,
My lord will also see paragraph 4 says of this letter that the guidelines dated 28/7/99/2021 and 21/5/2018 are annexed herewith for your reference, my lord. And the first line reads that these guidelines are to be followed during selection and nomination. And the guidelines, my lord, as we had read on the date when the matter was argued at length, my lord, the guidelines say that central government employees are to be treated at par
huh?
by state of Nagaland quota seats.
What?
That
Can't hear you.
am I audible, my lord?
Yes, now only.
Saying that, my lord, if your lordships will see paragraph 4 of the letter, the beneficiary state government, ministry, departments, in compliance with the guidelines of the ministry, issues guidelines to be followed during selection and nomination of suitable candidates. So, my lord, these guidelines which are to be followed are captured in the letter dated 28/7/2025, my lord, the letter that we had referred to in detail on the last date, my lord, when we had argued the matter. My lord, that letter itself says that central government employees are to be treated at par with the candidates of state of Nagaland, my lord, the domiciled candidates. May I take your lordship back to that letter, please? Which is at page 71, my lord, of the paper book, the petition filed by the petitioners. Page 71, my lord, 1.2.4, and then the unnumbered, my lord, sentence following 1.2.4.
What are you? Oh, just a minute.
Please, my lord. Page 71, my lord, of the paper book.
Just a minute.
Of course.
Yes, what do I say? Page 71.
Page 71 of the paper book, my lord, is that letter which governs the manner of distribution of seats. The guidelines, my lord, that are to be followed by the state of Nagaland, and as has been confirmed, my lord, in the latest letter issued by the Undersecretary, my lord, to the government.
Yes.
Your lordships will kindly see, my lord, these guidelines themselves tell us, my lord, how and who are eligible, my lord. 1.2.4 says the employees of central government, state duty government posted in and having their headquarters within the state duty concerned will be eligible. And then, my lord, the unnumbered sentence following that, the children of central government, state government, UT government employees aforementioned should be treated at par with the local resident. So, my lord, today, in my humble opinion, the view expressed by the letter, my lord, which has been shared by the learned CGC is that one, seats will be governed by these guidelines. There is no dispute there. Two, they say that there are two separate quotas. And the quota for defense ministry is in addition to the quota for state of Nagaland, my lord. They are not mutually exclusive. There is no mention in that letter saying that if you are covered under
You have
one,
to
you will not be
clarify
covered
this,
under.
Mr.
Otherwise,
Yes, my lord.
also may paragraph 6 of the letter, paragraph 6 of the letter. also.
Paragraph 6, yes.
Paragraph 6. So far as the matter relates to the treating of army personnel as central government employee in close so and so ministry's guideline, it is informed that these seats are allocated, my lord, may kindly pay. These seats are allocated to the state to compensate for the shortage of medical infrastructure and to provide opportunities for the student of the state. My lord, may kindly mark it. Student of the state to integrate into the main streamers.
Additionally, a separate quota is reserved for army personnel.
Army laws. That it is very specific laws. Very specific laws.
Okay. That's all I think. This clause 6 appears to be quite clear. Separate
My lord,
quota.
When Lord, see, as per the, we go by the petitions also, that particular petitioner, daughter is never a student of the state of Nagaland. Lord.
That is the difference.
Otherwise, Lord, see.
my lord, what this will amount to, my lord, if I
Last
may.
line also is
After it says additionally a separate quota, you see additionally.
separate quota for the army personnel. Lord.
Additionally.
It means, otherwise, wording may be defined, otherwise the is a.
Word additionally, that appears to show that it is in addition to this.
Otherwise, if your lordship may see in page 74 also, it's very clear that 74 at point 3. This says selection of candidates by beneficiary government department. The followings are the
Just a
beneficiary.
minute, where?
Page 74.3, right after 2.4,
Uh-huh.
just below 2.4.
Yes.
Selection of candidates by beneficiary government departments. The followings are the beneficiary government department. Number 1, Ministry of Defense, Kendriya Sainik Board for wards, children of defense
No, where are
personnel.
you reading? Page
May
74.
I, my lord?
Page 24.
Education qualification.
No, this
I'm
is
sorry to interrupt, my lord. This is point number 2 onwards, my lord, is applicable to the state of Jammu Kashmir, not to Nagaland. Kindly see point number 2, my lord.
Put him off for the time. Where is this? Where is this page 74?
74 of the appeal memo.
Huh?
Of the appeal memo. 74.
It talks of
It talks about the beneficiary government department, where the Ministry of Defense is also one of the beneficiary.
how does it start? How the first line?
one, Lordship, it starts at page 70. Page 70, this is the guidelines. This is the guidelines for the beneficiary state, UT, as well as the beneficiary department. Lordship, may turn to page 70. Here
Yes. So page 7. How does it start?
it starts as guidelines for allocation of central full MBBS BDS seats.
It said office memorandum dated 28/7/25.
Yes, Lordship.
Ah.
Yes.
Then page 74,
Page 74 is in continuation of this one.
but how does it start? It starts in the beginning for persons with disabilities at the
No,
top.
no, it comes to point three, because a person with disability talks about,
I understand, but I want to know which page we are in.
we are in page 74.
74. So
Yes.
page 74 starts with for persons with disabilities.
Yes.
That page.
Yes.
So that.
Yes.
Now which part of that
Yes, numerical
Three,
philosophy,
number
numerical philosophy, that
one? There is no, there are three. Okay.
Three. Selection of candidates
Ah.
by beneficiary government departments.
Yes.
The following are the beneficiary government departments. Number one, Ministry of Defense Kendriya Sainik Board for wards, children of defense personnel. So the petitioner comes under this category, not in the category of the central pool meant for the state of Nagaland.
there are three parts. So my lord may kindly, for clarification, my lord may kindly come to page 71 lordship. Page 71 lordship.
Yes.
Page 71 lordship. My lord got it lordship.
Yes.
First one is selection of candidates by beneficiary state and union territories.
Yes.
Then states will come and union territories will come. Then my lord may kindly come to next one lordship. 72, page 72, room 2 lordship.
Yes.
Selection of candidates by union territories of Jammu, Kashmir and Ladakh. My lord got it. Last page 72 lordship.
Yes.
This is a lordship another category. Then my lord may kindly come to page 74 lordship. Third category lordship. That scheme is lordship comprises three categories lordship. And first category central pool quota lordship belong to the union territories and other states lordship except Jammu and Kashmir and Ladakh lordship.
Where is that?
First one lordship selection of 71 lordship page.
States.
Selection of candidates beneficiary state and union territories. It is lordship excluding the state of Jammu, Kashmir and Ladakh lordship.
One.
Then my lord may kindly come to next lordship. Next page lordship 72 lordship.
Yes.
2. Selection of candidates by union territories of Jammu, Kashmir and Ladakh lordship.
Number 3.
Number 3 is lordship. Selection of candidates by beneficiary government departments. There includes all the departments lordship. That number 1 is Ministry of Defense. Then Ministry of Home lordship, Ministry of Home Affairs, External Affairs, Ministry of Education and Cabinet Secretary. So 3 categories are they are in the lordship or earmark lordship. So each category has a separate lordship quota. Defense is number 3.
Yes.
But what about 4 in 75?
75 lordship.
External affairs.
Selection of Ministry is the External Affairs lordship.
That is there in 3 also. 3 point.
For civilian, that is lordship 3.4 lordship. For what civilian or mission staff posted abroad lordship. They are the persons who are in the embassy lordship, who are working in the embassy, then it will come lordship.
Anything else?
No lordship. The OM itself very specific lordship. There is no lordship.
And Lordship, I may be allowed to produce one document regarding with the eligibility criteria under the Ministry of Defense Central Pool. Lordship, this is the instruction for applicants applying for reservation of MBBS BDS seats against CW. This is children and wards quota to the Ministry of Defense for the academic session 2025-2026.
Yes.
Eligibility criteria.
Yes.
A, scheme is open to Indian nationals only. B, only wards, widows, wife of defense personnel from Army, Navy, and Air Force from priority 1 to priority 9 are eligible for the scheme. Then come to D, wards of civilians working in FHQ, MOD, DRDO, wards of personnel from paramilitary CAF are not eligible. Then number E, this facility is admissible for only one member of the family once in lifetime, Lordship. So who knows the petitioner family may have availed on the earlier occasion, Your Lordship. That's why they are targeting the seat meant for the stake of Nagaland.
This CW means what?
CW means children, wards, or widow. So for the Central Pool MBBS seat, the Kendriya Sainik Board is the nodal department. They will do the selection and the nomination.
Where does it say that?
Lordship. Here, page 74. This is the, in bracket, 74, 3.1. 3, then comes to 1. Ministry of Defense Kendriya Sainik Board.
Anything else?
Lordship, otherwise, even in this documents which I submitted also, it's there. What is that? Lordship may come to 2 instruction.
Yes.
The following instructions are given for information and guidance of the eligible.
To where? To where is it?
2 of the loose documents which I submitted. Instruction for applicants here. Point 2. Instruction. Applying for reservation of MBBS BDSC quota for the Ministry of Defense.
Number 2, which one?
Of the instructions,
Okay, instruction then.
How,
Okay,
please read,
okay.
how does this start?
it starts at 1 eligibility criteria, then 2 instruction.
Yes.
The following instructions are given for information and guidance of the eligible applicant. A. Candidates are required to apply on Google form available website along with supporting documents as per given in paragraph 4 below. No offline application will be entertained. Serving personnel will submit application online along with scanned copy of documents duly authenticated by record office as per paragraph 4. And it comes to B. A wrong or misleading entry will lead to rejection of the application. C1. Selected candidates will be informed directly by the Kendriya Sainik Board, Ministry of Defense through email and telephonically about the date of counseling. Roman 2. Selected candidates who want to not appear in counseling should send willingness, unwillingness by email, telephonically, and also by post within specified date given by KSB. Format of willingness, unwillingness certificate is attached. So here the Kendriya Sainik Board, this is the nodal department to select and nominate the wards and the widow under the defense quota.
We have to send it to the Senate board.
Lordship.
We'll have to send it.
Yes.
Senate board.
Yes, to the Sainik Board. The formats also they have given, Lordship, if we can flip on the pages. If we flip on the pages, the eligibility criteria, the format is there. The willingness certificates, Lordship, everything has been included as annexure 1, 2. So the petitioner is ward children of serving army personnel, Lordship. So he comes under this category, not under the category meant for the stake of Nagaland.
So the state. Anything else? Anything else?
That's all, and I'm relying on the Supreme Court judgment, which I have,
What is judgment, huh?
Lordship with the para 13.
Ah.
Because the other day, my learned friend for the petitioner is saying that he talks about Article 310. So here, if the Lordship come to paragraph 13 of the
Yeah,
5 judges
yeah.
bench, the principal question which falls to be determined in this appeal is whether the appellant was holding a civil post under the union and could be dismissed from service only after an inquiry made in accordance with the procedure prescribed by Article 311 of the Constitution. it is common ground that if Article 311 of the Constitution applies to the applicant, the requirement of Clause 2 of that article have not been complied with. By Article 310(1), every person who is a member of a defense service or of a civil service of the Union or of an All India service or holds any post connected with defense or any civil post under the Union holds office during the pleasure of the President, and every person who is a member of a civil service of a state or holds any civil post under a state holds office during the pleasure of the governor of the state. The first part of Article 310 classifies the servants of the Union into 5 categories. 1. Members of the Defense Service. 2. Members of Civil Service of the Union. 3. Members of an All India Service. 4. Members holding posts connected with defense.
No,
5.
how does the judgment help you? Because look at page 71. Look at page 71.
Of the appeal memo, Lordship. Yes. No, this one I'm to show that even a person who is holding a post connected with the defense, the Supreme Court says that he is not holding a civil post.
No, that is all right.
Yes.
He doesn't say that he's holding a civil.
Oh, Lordship. So what?
That is not the issue.
No. What we are contention of the
Whether a person who is holding a defense post under the union can is eligible. There's no bar out here
Mm.
let us see page 71. Where does it say that only
No, it
the wards of persons holding civil posts will be entitled?
No, Lordship, it talks about the central government employee. Central government employee.
Where?
Where Lordship come to 71, 1.2 eligible condition, subclause 3.
Yeah.
The employees of the central other state duty government on deputation to the state duty concerned. And number 4, the employees of the central other state duty government posted in and having their headquarters.
It does not differentiate between civil and defense.
No, for this category, Your Lordship, for the purpose of central pool, it talks about only about the civil post, not about the.
Where does it say civil post? Where does it say civil post?
It doesn't say, because in general parlance, Your Lordship, the army, they can be termed as central government.
Look, your very judgment.
Mm.
This shows that you see, it shows that a person who holds a civil post or a defense post under the government is an employee of the center.
Yes. So, Lordship, if you come to para 16, it clearly says, para 16. As already observed, Article 311 applies only to the dismissal and removal from service of members of civil service of the Union or of an All India service or of person holding civil posts under the Union and not to the members of the defense service
Yes,
or service connected with defense. Protection of Article 311(2) of the Constitution could not therefore be claimed by the appellant. The Civil Services Classification, Control and Appeal Rule, which I am relying in this case, apply to person in the whole-time civil employment of a government of India, and the appellant who holds a post connected with defense is not within that description. So, Lordship, if we consider that the petitioner is if this guideline does not differentiate between a civil post or a military post, if we assume that also the petitioner further is not eligible because his headquarters should be at Nagaland. NCC headquarters is not in Nagaland, Lordship.
NCC headquarters, where is it?
The NCC headquarters is in Shillong, not in Nagaland, Lordship. So if at all he comes under that category also, he is not eligible, Lordship.
So he does not come under 1, he does not come under 2, he does not come under
3.
3, because he's on deputation.
He is on deputation, Lordship.
As another others on deputation to the state.
Yes. So, Lordship, he does not come under that.
He does not come under 3.
None of the
So
category
only
also.
4.
Yes.
Only 4. So he's claiming under 4, correct?
Yes. Because he is on deputation. And his deputation will expire next year.
Anyway,
Headquarters or nothing.
Yeah, headquarters is not in Nagaland.
Mr.
Lordship.
Counsel, yes, put him on, put his view.
Please, my lord.
Okay, yes. So you are claiming the MBBS seat under 1.24, correct?
Yes, my lord, I am eligible under both 1.23 and 1.24.
1.23 and 1.24.
Please, my lord, because this gentleman
What are
is
the-
deputed to the NCC.
Employees of the central or the state duty government on deputation to the state duty concerned. So what are the single bench heads? That we are eligible under what?
1.4, 1.24.
1.24. Where does it say that?
Lordship, page 50,
Hmm.
para 50.
Yes.
The petitioner, who is the daughter of Colonel Lovelish Pangal, who is posted as the commanding officer of one Nagaland battalion,
Eligible under
category 4 of the Office Memorandum 28/5, July 2025.
and what is the petitioner's case? Does he claim under which provision?
Lordship is not claiming this provision.
Okay. So now he's saying he's eligible under 1.23 also.
No, it could not be because NCC is belongs to the armed forces. It does not belong to the lordship, to the state or to the central. It's an armed force, youth wing lordship.
Ah.
So the headquarters is in Shillong. Not Nagaland has a unit lordship.
Are you on deputation?
Yes, he's on deputation.
If he's
Manoj,
on deputation, then why not? Why would he be employees of the central other state duty government on deputation to the state?
Lordship, that's why I'm saying that the NCC
Can't the
post
can't army officers be on deputation?
they can be
So then,
on deputation,
Uh.
but the thing is that that belongs only to the armed forces, not to the state government lordship.
oh, on deputation to the state. Okay.
Not he is not on deputation to the state. He is on deputation to its own unit.
Uh-huh.
Yes.
Then he's a central government officer. He is not on deputation to the state government.
Yes, lordship.
Let us see the writ petition.
Lordship, page 78 is the writ petition. First one, 134 of 2025. Lordship, in this case, the petitioner name was not listed in the provisionally merit list, for which he has filed this writ petition.
What has the learned single judge said about 1.23?
Lordship, it will come under page 47. Page 47,
Yeah,
para 42.
yeah.
Clause 1.2 of the office memorandum provide as follow eligibility code. I need not read this. Then 43, from above guidelines issued by the central government, there remains no doubt the children of only 4 categories of persons are eligible to be considered for selection and nomination against central pool MBBS seat for the academic year 2025-26. It also prescribed that the children of central, state, UT government employees should be treated at par with the local resident, which means that there is no stipulation for providing any preferential treatment to any of the 4 categories mentioned in clause 1.2 of the aforementioned office memorandum. 44. It is also pertinent to note that the aforesaid memorandum does not provide any specific provision for children of all India service officers born on the cadre of the beneficiary state. 45. The court agrees with the submission of the learned advocate general that the father of the petitioner, being an army officer, cannot be regarded as an officer of all India services of the Nagaland state cadre. As per section 2 of the All India Services Act 1951, the expression an All India service means the service known as Indian Administrative Service or the service known as Indian Police Service or any other service specified in section 2A. The next section provides for other All India services, which includes the Indian Services of Irrigation, Engineers, Irrigation Power, Buildings and Road, the Indian Forest Service, and the Indian Medical and Health Service. Thus, it appears these 5 services may be regarded as All India services. Then 46 is the state guidelines notification. And page 49, para 47, your lordship. On perusal of the aforesaid, 47 is also, it talks about the state guidelines. 48. We have discussed in paragraph 45 of this judgment herein above as to what constitute an All India service. All the employees of central government posted in and having their headquarters in the state of Nagaland may not be regarded as officer of all India services born on the Nagaland cadre. It is therefore apparent from the impugned notification that it totally excludes the children of central government employees posted in and having their headquarters in the state of Nagaland from the eligibility criteria mentioned in the category 3 of the impugned notification. This one talks about category 3. This one talks about the government notification, not the Union of India.
This talks about 1991. I mean, this
21.
990
Yes.
21.
Then
I no, it has. What about this 1.23 of this office memorandum of 2025?
so, your lordship, here, page 50, 49, para 49. Thus, though as per the office memorandum dated 28 July 25, prescribing the guidelines for allocation of central pool MBBS BDSC for the academic year 25-26 issued by the Government of India, Ministry of Health and Family Welfare, the children of the employees of the central government posted in and having their headquarters within the beneficiary state are eligible to be considered for selection and nomination against central pool MBBS seat for the academic year 25-26. However, the impugned notification such and such dated 9/9/21 issued by the Government of Nagaland Higher and Technical Education Department totally exclude the children of central government employee except the children of all India service officers born on Nagaland cadre. This stipulation in the considered opinion of this board is contradictory to the office memorandum dated 28 July 25, prescribing the guidelines for allocation of central pool MBBS BDS seat for the academic year 25-26 issued by the central government. It also militates against the principle of equality as enshrined in the Part 3 of the Constitution of India. Such a stipulation is also violative of the
No,
fundamental rights of-
again.
Yes.
Come to 1.23 at page 47.
Lordship, 1.2.
Yes. The employees of the central, other state, UT government on
Deputation to the state UT concerned. That
So the state and UT concern doesn't mean the government. It means to the state.
It means
Certain.
to the state, it means, that means a central government employee on deputation to the state department, lordship. It
No, no, no.
State.
No. It doesn't mean to the state government, no.
The employees of the central other state government on deputation to the state duty concerned. Then number four makes it very clear. The employees of the central other state duty government posted in and having their headquarters within the state. Within the state, lordship. This number 3 and number 4 makes two different it distinguishes, your lordship. Number 3 talks about a central government employee posted to the state. And number 4, it talks about lordship, it talks about the central.
See, the only difference is headquarters will be within the state.
Yes,
Otherwise,
yes.
otherwise, lordship, lordship kindly pairs again, lordship. The employees of the central, other state lordship, and union government lordship.
Yes.
On deputation to the state and union territory concerned lordship. The employee who are a central government employee, an employee from the other state, an employee of the union territory lordship, who are deputation on the state concerned lordship, state and union territory concerned lordship. Again, kindly read lordship. The employees of the central, other state, union government lordship, and union territories of government on deputation to the state and union territory concerned lordship.
You see the deputation to the state.
Deputation to the concerned state or concerned union territories lordship. The employees of the central government,
You mean to say it pertains only to the state government or the union territory government,
where
UT government,
State-
that is not to the territory.
it means lordship, as my understanding lordship, the employees who are a central government employees or other state government employees or other union territory employees lordship, who are on deputation to the particular state and union territory concerned lordship. Here lordship, particular state is the lordship, state of Nagaland lordship.
Mr. Gogoi, you see one thing, this is 1.23, the employees of the central other state duty government.
Lordship,
Just stop there.
lordship.
Now, the employees of the central other state duty government can include defense, can include civilian. There is no distinction.
There is no distinction, otherwise
Distinction made between this, it is applicable only to the civil officer.
no
So
distinction.
it can be applicable to the defense also. on deputation to the state.
State, but she must be a deputation to the state government also.
Is it to the state government or to the state territory?
State
Or the
or,
union territory? Or the
state or
union
union territory concern also.
concern, that's what.
Right.
Not, that doesn't have to be to the government.
That's it.
It can be to a, supposing
Yes, sir.
an army officer, like you see Assam Rifles.
Yes, sir.
They, Assam Rifles, their commandants are all army officers.
Yes, sir. Yes, sir.
When they come to the Assam Rifles, they come on deputation
Yes, sir.
3 years
Yes, sir.
and become commandants
Yes,
of certain battalions. And then they go back.
Yes, sir.
So they become commandants on deputation in the territory, okay, with regard to a central government force.
Yes, sir.
But it is not to the state government, it is to the
So
state.
that within the territory
Within
of
the
that
state.
particular state.
So will they come under this 1.23
Yes, sir.
and 1.24? 1.24, okay.
Yes, sir. Yes, sir.
Shillong is the territory, Shillong is the capital.
Shillong is the
Commander.
headquarter of the.
Quarter they cannot
state.
come under.
Yes, sir.
But will they come under 1.23?
No, otherwise, there is no specific wording that he should be in the particular government also.
Correct, that is why we need a clarification.
Particular government also.
Yes, Mr. Petitioner. Yes. Yes, Mr. Akshay.
Please, my lord. My lord is absolutely right, because my lord, there is a conspicuous absence of the word government after state and UT concerned. Number one. Number two, my lord, I have to reiterate that the petitioner's father has his headquarters at Kohima, my lord. It is headed by a brigadier level officer of the Indian Army. The headquarters are not at Shillong. In fact, my lord, no such ground has been taken in the LPA, in the appeal. My friend today is making a submission which is not there on record, and it is not verified in facts. The headquarters are at Nagaland, in Kohima. There are, my lord, 4 different NCC offices. 3 come under the army, 1 under the Air Force.
Hear you.
Army and 1 under the Air Force, my lord. And then the army ones are headed by a brigadier sitting at Kohima.
Can we clarify this aspect? 1.23, 1.24. To the, you see, it says here 1.23, just read.
Yes, sir.
The employees of the central / other state / UT government.
Yes, sir.
It's all right.
Yes, sir.
Government is there. On deputation to the state / UT concerned.
Yes, sir.
Not say government.
Yes, sir. Yes, sir.
Lordship, according to my understanding, Lordship, it means to the, it talks about deputation to the state.
Correct.
So it means that under the State Department. That's what I understood.
No, you see, that is what.
Otherwise, Lordship, and paragraph 4,
Madam, you see, the problem is, the problem is you are only looking at things
Interpretation
from
in the
the
both ways also.
yes.
lens of a civil office,
Mm.
a civilian government officer. You're not looking at it from the prism of a central government officer, which could also mean a defense personnel.
Yes, Lordship. On that perspective, also my understanding, Lordship.
Understanding
Yes.
is very important, but let us ask the
Chief,
central
Chief,
government what is their interpretation.
Interpretation is the both ways also. You go by that law.
Let us
That is
get
the
this
issue.
information,
That is why.
get this information
Yes, sir.
as to whether deputation would be, because otherwise, why should they be discriminated?
Yes, sir.
Yeah, because what they are trying to now, what they are saying is,
Yes, sir. Yes, sir.
that this letter, that this note they have given,
Yes,
that's
sir.
para 6.
In addition, what Losik, some
Yes,
confusion.
additionally,
Yes, sir.
separate quota reserved for other person. So it's addition, they will there. So besides the state quota, additionally they will
Yes, let
given.
them come clear.
Yes.
Lordship.
Or it can mean the other way also.
Mm.
For the state government official, or whoever comes there, they are also giving additionally this.
Otherwise, the above line also, the order shortest from starts from third line also. State to compensate for the shortage of medical infrastructures and to provide lordship.
Those are the.
But disturbing what is the additional lordship?
Yes, so
State government partner.
That can be lordship. That is not difficult. That can be.
Public-
Probably in the lordship, in the department, some lordship, department, particular lordship, corporation is there lordship under the department.
that is hardly.
Then also hardly that part is there lordship.
Usually it's not.
Usually it is not. Usually not.
See, only thing because what comes to mind is this somewhere. So the employees of the central or the state duty government on deputation to the state duty would mean to the state duty where a similar kind of office is.
State duty concern also.
They have the headquarter, if they have the headquarter, even in,
So
yes.
if a person cannot come to a state government.
No.
It's like he's serving in the territory.
Yes, only
Not of-
four.
So we want a clarification with regard to
Press
this,
number 4 only.
not 3 and 4.
Okay, no.
Whether this deputation to the state duty concern means to the state duty government.
Or.
Okay, whether
Yes.
concern, that word concern, a 1.2 and 1.23 and 1.4. That word, whether that word concern would mean government,
Particular state government.
government or territory.
Also.
What? Territory has a different meaning.
Lots of, then,
Whether it is the government.
lots,
If it's the government, then it's good.
lots of.
Yeah. And whether in this case also there be also. So when can you give us that information?
Only make it this week.
This week, Lossy may posted it, Lossy after vacation. In the meantime, once it is up, there will be no difficulties. Lossy, the central,
But the problem is there.
central pool quota Lossy, they can
No.
fill up others, Lossy.
Then if that is the case, then
They can fill
lordship
up the
may
others.
modify the interim order.
Ah.
Because
What is the interim order say?
lordship on 19,825. 19,825.
Yes,
The last paragraph.
yes.
Till such time, the operation of the impugned judgment dated 14,885 passed by the learned single judge shall remain in abeyance with the rider lordship, that one seat shall be kept vacant, which shall be filled up after the decision in this appeal. And the last date is 8th of October.
It is not difficult. If Lordship by way of court order, it will be Lordship, then it will
We
be
can,
not difficult.
we can.
Lordship. Once it should
We
be,
keep it, we can, once.
if they can Lordship, as and when Lordship says,
Which can be filled up in terms of the order of this.
Lordship, Lordship. Otherwise, in the short period, Lordship, I
Is the concerned authorities, are they made parties here? Ministry of Health. Okay. Yes. What petitioner?
Yes, my lord. Just one thing, my lord. As per the merit list, my lord, the private respondent is placed at serial number 2.
Maybe.
Now, my lord, it is important that one seat has to be saved, my lord, and the merit list also, my lord, then will have to be varied as per the directions of the Honorable Court, my lord, subject to the decision in this petition. Because otherwise, my lord, if in case, my lord, the respondent is successful and this appeal is dismissed, just, my lord, as an example, my lord, she then deserves the seat which should have gone to serial number 2 in the merit list. So she should have the second choice, my lord. That is the only thing I want to clarify. That's all, my lord. Otherwise, my lord, we are awaiting instructions. I
Look, today is,
go down.
you see, the court is opening again on 12th. So it'll be decided on 12th or 13th. And 8th is anyway, 8th is Wednesday. 8, 9, 10, puja time. Nothing will really happen. 8, 9, 10. 3 days. Mr. Gogoi, can you give a affidavit so that we know the stand of the government very clear?
Madam, may kindly reflect with order of that. That query Lordship, which we have to ensure it Lordship, then it will be well. Only that aspect Lordship.
So we release it for part? I thought we will decide, but yeah. Otherwise, we don't know whether we'll sit again or on that day. I think. I think we'll release it from her because my brother will be sitting in Kohima. On the thing. So let it go before the. We'll go to code number one. Code number one to decide. But let there be a clarification on this. All this issue is there, that's all.
Last solution.
Okay, right. Heard Miss V. Satya Leonard, AG, Nagaland. Also heard Mr. K. Gogoi, Leonard CGC of the Union of India. And Mr. Akshay Bhandari, Leonard Counsel for the Private Respondent / Writ Petition. Next part. The issue to be decided, no, this court, no, the Mr. K. Gogoi had been directed right order dated 8/9/2025 as to whether clause 4 of the office memorandum dated 28/7/2025 would include army officers. Mr. K. Gogoi has submitted letter number C18018/015/2025-ME-Roman 2 dated 17/9/25 issued by the Undersecretary to the Government of India, which is addressed to the learned CGC, which states at para 5 and 6 as follows, huh? Take it 5 and 6. No. Initial X. No, if you will finish. The issue pertains to. No, that's it. The present appeal is a challenge to the judgment and order dated 14/8/2025 passed in WPC 134 of 2025, wherein the learned singular had held that the respondent, private respondent / writ petitioner was entitled to the grant of one MBBS seat for the academic year 2025-2026 against the central pool of MBBS allotted to the state of Nagaland, against one of the 42 MBBS seats allotted to the state of Nagaland under category 4 of the office memorandum dated 28/7/2025. Next part. Clause 1.2. You just take this, huh? Page 47, para 42. Next. Then next. Ms. V. Supre, the learned additional AG submits that clause 4 of the office memorandum dated 28/7/25 is not applicable to the petitioner's case, to the writ petitioner's case, in view of the fact that the headquarters of the NCC, in which the petitioner's father who is a commandant, is having its headquarters at Shillong and not in Nagaland. Next para. The next question that arises is whether the word concern, inverted commas, concern, in clause, in clause 1.2 bracket 3 would mean government or territory. Next para, Mr. K. Gogoi shall accordingly submit an affidavit specifically stating as to whether the petitioner is applicable to be granted or to be allotted one of the 42 MBBS medical seats allotted, central seats allotted to the government of Nagaland in terms of clause 3 and 4 of the said office memorandum dated 28/7/2025. This is the matter on 13. As one of us is going to sit in one of the outlying benches on 13, the matter is released from Pata.
Lordship, the interim order may continue.
The interim order to continue till the next week.
Okay, much obliged.
Program also may kind
Grateful,
of tilos,
Huh?
tilos, our instruction tilos.
Okay,
Just.
you make it 3 also, huh? 3,
Just.
Three.
Just.
3.
Tilos.
Okay, yes.
Tilos.
Yes.
Our duties on up to the allocation part, then nomination part also it is.
No, I'm not a nomination. We want to know whether they are eligible or not. That's all. Nomination to will, the government will do. The only thing is whether, what is their stand, whether the central government is eligible. I mean, the defense personnel are eligible to be considered under clause 3 and 4. That's all.
Much obliged.
Always also.
Please, the matter of partner website, no? We have to be clear, madam, otherwise. That part.
No, otherwise if it's very clear, Lordship, the defense would not come under this category.
I don't know, let's see.
But it is the union who
It is
has
not,
the.
it's not clear.
Lorships.
Always also.
It's fine. You give this back, this judgment, I think you did it.
No, I have agreed.
This situation has been preferred under section 5 of the limitation.
Heard Mr.
Yes, Islam.
S. Islam.
Yes,
The name is not here. Acha is here.
I am the filing.
Counsel for the applicant to submit that there is a delay of 23 days in preferring the appeal against the conviction of the applicant under section 6 of the POCSO Act. Addition PP submit that she has got no objection to the delay being condoned accordingly. And the delay of 23 days is condoned. The registry to list the appeal after the vacation is accordingly disposed of.
Yes, for Lordship.
US Bora. But that there is a delay of 18 days.
180.
Huh?
18 days.
18 days. In filing the appeal against his conviction under,
Not conviction.
no, against the rejection of his bail, against the rejection of his prayer for bail by the learned in High Court. Mr.
D. Bharadwaj.
D. Bharadwaj, learned That special.
Public posts.
There are people, submits that has got no objection. 18 days.
Huh?
8 days.
notice.
Submits that has got no objection to the delay being condoned. In view of the consent of the party, the delay of 18 days is condoned. Registry to list the appeal after the vacation. I have accordingly disposed.
Most please.
Lordship, letter may be passed over for time.
Why? Why?
Seniorly like that, Lordship.
Oh, there's nothing here. What is this? Actually, I had dictated the whole thing. I finished, but I don't know where this process is.
376. Lordship, that matter,
And-
with DNA profiling, the result came in favor of them.
Wait, huh? Okay, right. Heard, yes, madam, what is yes. Heard Mr. A. Ahmed, learned counsel for the appellate. Also heard Ms. B. Boyan, learned additional PP for the state.
So I is there, Lordship.
Huh?
I is there,
Posing of the entire thing.
Lordship.
The entire. That-
Lordship.
I think because the evidence of that securities is that she didn't identify
Lordship.
the the attacker on that faithful. Then where's the question? Nothing remains. Just a minute.
He named the accused person. Page 10 of the deposition provided by them.
Page 10.
Sudeep stopped me at Majipara, gave my mouth and
Hey.
told me not to shout. Evidence of PW7.
Page 10. Yes.
The second line, Sudeep stopped me at Majipara. Yes.
10 is the.
Evidence of deposition of PW7 compilation. Compilation is learning.
No.
In the compilation provided by the appellant side.
This page. Okay, put this one. Page 10.
But in cross Lordship, I came to know his name only when the case was filed. Page 11. Joyamati told me the name of the accused.
Oh, this is different. Wait, this is different. This is, this is different.
I have not seen
No,
the.
this is
case
different.
paper.
This is different. Page 11. Across, page 11. Second paragraph. I have not identified Sudip to Joymoti. Who is Joymoti?
Joy Moti.
Joymoti, Lordship.
The ladies told me the name of the accused as Sudip, alias Bura. I have not seen the face of the person who caught me on that night due to darkness. I was asked by the ladies to file the case against me. I would not have revealed the incident if the women of our village would not have inquired me.
But the victim was mentally ill, my lord.
That is the problem. Now,
And in the next para, Lordship, I have.
that is the problem. Now, she did not see the face of the person. And then she says that I was not knowing his name, not knowing the accused prior to the incident.
True.
How did she identify? After the incident, I knew him. I was not knowing his name. I came to know his name only when the case was filed. Joy Mati told me that the name of
But
the,
he was from her same village. She used to know the mother of the accused person,
okay.
but did not know the accused person by his name.
Okay, she did not know the person by his. But she says that I have not seen the face of the person who caught me on the night duty darkness.
Same. But that's my list to file a case of this. And in the next para, Lordship, I have implicated the accused on being pressurized by Joymoti and Kulkumar.
So another factor is since DNA profiling report has come in favor of them, like it was not identical. Then even if I lordship, leave it to a lordship, to a lordship.
Because how are you going to convict now?
Otherwise, like pressurizing and all these things, these are not factors. The only thing is that like.
Identity.
DNA profile.
Identity.
Otherwise, if the victim may not be willing to file a case, somebody will have to clear if we file a case.
Lordship.
So that's not a factor.
If she is of sound mind, my lord, she would have filed a complaint against the person, but lordship in her deposition, because she was mentally ill, my lord. She has deposed like that.
The problem
Unless
is that,
her stomach,
but the
bulging
child
out.
is not his.
The report says,
not a
madam,
biological
whether it is conclusive.
DNA is conclusive. You see the literature on DNA, 99% conclusive. DNA is the most everywhere you, especially in America and all, you see the amount of DNA is being used. Profiling, so much of profiling there. There is a TV show dedicated only to no, yes, with regard to who is the father of the child. And that is proof. And here also in our courts, Supreme Court has given so many judgments of all.
This has started usually from that. Recognition. Yes.
Only in cases of family, all these affairs where the genuineness of the sibling is in question, that time court is more careful.
There, of course, there are some which say that not infallible, reliability is. But then you see, even in the CRPC, 52A is there for DNA profiling. And in BNSS also it is there. The IO can direct
At the time of investigation.
the
itself.
investigation. The courts also can do it as a provision.
391 earlier.
I don't know the exact, but it is there. So the Bombay High Court has said so much things about this DNA profiling. The only thing is see, the infallibility of a DNA profiling is not with regard to the results. It is with regard to the playing with the chance of tampering with the samples at the time of
Collecting.
the time of taking the sample. That is the time you're going to be very careful.
Lordship,
Instead of
my lord, victim is like mentally ill. Lordship.
not that victim is not a problem.
My lord.
Whether they have taken the child's sample and the accused person's sample.
Yes, so
So
they
that
say
that
jail
is
authorities,
that is the
jail authorities have collected, but.
no, out here we have directed the court to do it. It should be done in the presence of.
But in presence of court, okay? Yes, it was done. Report says so.
I think we have directed the court to do it. That shall also ensure. Uh, So we have done it. What more? Only the problem is, you see, at the end, there might be a lot of arguments on both sides with regard to the question of whether the victim is mentally sound or not. But the fact remains that in the cross-examination, she has said so many things. Now, so first thing is, if she is not mentally sound, whether her evidence can be said to be foolproof, whether we can take it to be the gospel truth, whether it's trustworthy, or should it be corroborated if she is mentally unsound. Similarly, her cross-examination is there. So nothing is sure.
Everything boils down into that report.
Correct. At the end, because especially for a mentally unsound, I understand if it's a person who is of sound mind, she might have had 2, 3 affairs. She might be having a boyfriend, might have been she might be married, might be. So it's possible that someone other than her partner or husband committed rape. But here we're not sure.
So she was a married lady, her husband expired having kids.
Married lady expired. But then now you're asking that, and then if she's of sound mind, say she's of sound mind, then order dated 13/10/23, huh? Para 3, para 4. Para 4, the first sentence only, okay? Para 4, the first sentence. Para 5. I mean, it take 3, 4, 5, everything. 3, 4, 5, 6, 7, 8, 9, 10. Then you write. This court, by order dated 13/10/2023, and directed that additional evidence was required to be taken in terms of section 391 CRPC. by having a DNA test slash profiling of the appellant and the child born to the victim, to prove whether the child had been fathered by the appellant. Full stop. The learned trial court was accordingly directed to take additional evidence for having a DNA test slash profiling done on the appellant and the child of the victim. Full stop. Next, consequent to the above direction passed by this court in its order dated 13/10, in the order dated 13/10/2020, the learned trial court has submitted a report dated 8/11/2024 issued by the Directorate of Forensic Science, Kaili Para. Dr. Manalisha, MANALISA Chowdhury, Senior Scientific Officer, Directorate of Forensic Science, Kaili Para. Before Kaili Para is DNA typing unit, before Directorate, DNA typing unit. Kaili Para. Appeared before this court on 5/9/2025 and stated that in terms of the confidential report dated 8/11/2024, the appellant was not the father of the child born to the victim. Next. The above fact having been cleared, the issue pertains to the next issue to be decided is whether the evidence of the victim was sufficient to convict the appellant. Keeping in view the fact that the appellant had been convicted on the sole testimony of the victim. In the case of Rai Sandeep versus State NCT of Delhi, the Supreme Court has given meaning to the word sterling witness. For a conviction to be made on the basis of the sole testimony of a prosecutrix, the victim would have to be. The victim's testimony would have to. The evidence given by the witness, by the victim, would have to be of a sterling quality, and as such, by a sterling witness. In the present case, it is the submission made by the additional PP that the victim was mentally ill and was unable to recall previous incident. Be that as it may, we would have to look into whether the evidence adduced by the victim was enough to inspired the confidence of the court and was trustworthy enough to convict the appellant. Next paragraph. The evidence of the victim back PW7 is to the following. Page 10 and 11. Okay, I'll put this blue one. A reading of the testimony of the victim and especially the cross-examination shows that the victim had not seen the face of the rapist during the time she was raped. PW7 has stated that she came to know the name of the rapist from one Joy Moti. First off, however, neither has Joy Moti been made a prosecution witness, and neither has any evidence been given by Joy Moti. As such, there is a huge gap as to how the appellant's name came to be the rapist. No, there's a huge gap as to how Joymati came to know that the appellant was the rapist. In her cross-examination, the victim has also stated that has denied the suggestion that she got pregnant because some other person other than the appellant had impregnated her. However, as per the DNA test report, the stand taken by the victim is found to be false, as the appellant has been found, as the appellant is not the father of the child conceived by the victim. On considering all the above, on considering the above evidence of the victim, we are not inclined to go any further into the evidence given by the other witnesses, in as much as none of them were eyewitnesses, and neither did they know. The thing is that the bichar was held.
2 times Bichar was held, he did not turn up. Lordship, there is 160, although they have not annexed it,
Did not turn up, then what to do? They did not turn up.
164 statement is also there. Lordship, they have not
But in
annexed it.
164, we'll have to corroborate the testimony.
Yes.
Na? Then where's the question of 164? What have we said? Inasmuch as the testimony of the victim does not prove that the appellant had raped the victim. That's what, next para. Where is the judgment of the trial court? What is the ground taken by the learned trial court?
Para 24 of the judgment at page 28 of the criminal appeal.
There are 24. Is 28.
The next para, the learned trial court had convicted the appellant on the ground that the victim had become pregnant due to the appellant raping the victim.
Para 29, a judge, while appreciating the evidence of victim, more particularly a rustic woman, should not insist on very technically.
And on the ground that in cases involving a rustic woman, comma, court should not insist on technicality. As the pregnancy of the victim had been proved, comma, the statement of the victim that she had been raped by the appellant would have to be accepted. However, as can be seen from the DNA test dash profiling done on the appellant and the victim and the child, comma, the father, the appellant is not the father of the child. As such, the very basis for the learned trial court to have convicted the appellant does not have any legs to stand on. Further, the appellant, the victim came to know of the name of the appellant only on being told by one Joymati, comma, whose evidence was however not adduced by the learned trial court. On considering all the above, we cannot agree with the findings of the learned trial court that the case against the appellant has been proved beyond all reasonable doubt. India, the green state above, the judgment not being sustainable, comma, we acquit the appellant from the charges framed against him under section
376 1.
376 bracket 1 IPC and
Only lordship.
consider consequently, the respondents are directed, the respondents, comma, especially the jail authorities are directed to release the appellant from jail immediately.
If he's not
No, he is in.
Huh?
in connection with any other case, he's not. May not.
No need, that is their final. The send back no, the appeal is accordingly allowed. The send back the PCR, then in the you're right, in view of the sense, dispose of accordingly.
That is May I please?
Lordship, notice is served, Lordship.
Item 5. Yes,
My lord, some instructions are due on my part. I could not take it some more time, my lord. After puja, maybe 16 or 17, my lord. I could not connect to the phone numbers. My lord.
you cannot contact whom? Your client.
Yes, clients, relatives, my lord, because they, my lord.
Are not
Yes,
fully received.
police. Maybe 16 or 17. In the meantime, I'll.
Only part instructions have been received. Okay, on the prayer for adjournment made by the counsel for the appellant, who submits that she needs further instructions from her client. This is the matter after vacation. We on
On 16th,
16th. Then you write, next, Miss A. Begum, additional PP has submitted letter, no, submitted letter issued by the, what is this? SI, police of Kanpur PS. Kanpur PS, showing that the respondent number 2 has received the notice. Accordingly, notice deemed to be served on the respondent number 2. This is the matter for hearing on 16th. Yes. So, the Aizal bench is not here, huh? Then, where is the staff? None of them. What? So are they objecting? They are not objecting to this.
Then this is first time it has come up. It is just a that you
I know, just a correction. Small
Corrections.
thing, that's what. You should have told them that to appear.
I informed them. They said that they are not they are not instructed to appear in that.
Okay, right. Third,
And
Mr.
N. Barwa.
N. Barwa, learned counsel for the applicant who submits that minor correction slash modification of the
Order dated 27/5
order dated
27/5
27/5/2020. No, the order dated 27/5/2025 passed in
PC 8 of 23.
WPC 8 of 2020 needs to be made. In as much as the phrase inverted commas show cause notice dated 25/8/2022 at paragraphs 3, 4, 6, 7, 9, and 10 of the said order is to be replaced by the phrase bracket, not bracket, inverted commas, fact finding letter dated 25/8/2020. Inverted commas. Next paragraph. On reading the contents of the writ petition, this court finds that the said letter dated 25/8/2022 is a fact finding letter and not a show cause notice. Agree with the above? The phrase inverted commas show cause notice dated 25/8/22 at paras 3, 4, 6, 7, 9, and 10 of the order dated 27/5/2025 is substituted slash replaced by the phrase inverted commas fact finding letter dated 25/8/2020. The IA is accordingly disposed. It is in the prayer portion, huh? I